Welcome, everybody. My name is Liz Rose, and I am the Communications Director for the Economic Policy Institute, and I want to welcome you all here today. First, I want to mention that we are recording this session, so you are being recorded, the civil libertarians among us, right? On behalf of the American Prospect and the American Constitution Society, I want to welcome you to Sex, Lies, and Justice, a discussion of campus sexual assault, Title IX compliance, and due process. Like so many liberal feminists, I heard about the Obama administration's efforts to crack down on sexual assault on campus, and I was pleased that someone is doing something about a long-festering and often ignored problem. The due process rights of men accused did not honestly occur to me until I picked up the American Prospect and read Judge Nancy Gertner's mind-blowing piece on this topic. And then I was delighted to read Alexandra's piece responding to Nancy's piece, which we're here to discuss today. There is nothing easy about this discussion, and yet I am extremely delighted to have this powerhouse panel of women here to speak on this difficult topic. The panel will be led ably by Caroline Fredrickson, the president of the American Constitution Society. Caroline is the perfect person to lead this discussion. She has feminist street cred as the former general counsel of NARAL, as well as civil libertarian bona fides from serving as the director of the legislative office of the American Civil Liberties Union. And she has a long list of other great qualifications that you can read about in your packet. In addition to her many legal and policy successes, Caroline is the author of an about-to-be-released book called Under the Bus: How Working Women Are Being Run Over. And I want you all to know that we will be having an event here at the Economic Policy Institute to talk about women in work and to talk about Caroline's book, and you can all look forward to being invited to that. But that's in the near future. So first, let's tackle today's discussion. Caroline, it's all yours.
Well, thank you, Liz. I will not get too close to that. So, as Liz said, this is a very complicated, emotional issue, and I think I probably speak for all of us in stating how many conversations I've had with people about the topic and how many sides I've been on in those discussions. There's a lot of weight on both sides, and the question is really how do we work our way to policies that are fair to victims, that are ensure the due process rights of accused, and that ensures that the proper functioning of Title IX is supported and advanced by the way that we look at these policies on campus. So, as Liz mentioned, we have a superb group of people to talk about this who have put a lot of thought into considering what types of policies should be adopted on campus, what are the important procedural requirements, and how do we create an environment for women and for men in the campus where their rights are respected and they can get the education that they came to school for. So I want to start with Nancy, who, and I'm not going to give any long introduction of any of the speakers. You have a printout, but Nancy has worn a lot of hats, and she is now a professor at Harvard Law School, has been a federal judge, and has worked doing criminal defense work as well as other ground-blazing litigation, much of it about women and women's rights. I'll do the quick introductions first, and then we'll turn to Nancy for the first question. Alexandra Brodsky, and I've just been trying to get my Russian up. I'm on my way to Russian, so I wanted to call you Alexandra Brodskaya, but
that works.
Back in the old country. So Alexandra comes to this with incredible credentials as well. She's at Yale Law School and is an editor at Feministing and is a co-editor of a book that is about to come out on women. And I'm sorry, I forget the title, but you can
soon to be a major motion picture.
Yes. Starring. And then, of course, we have Lisa Brown, who's the general counsel of Georgetown University, has served in the Obama White House, in the Clinton White House, was a partner at Shea & Gardner, and I will selfishly say the most important part of her resume was that she served before me running the American Constitution Society, for which I am deeply and will ever be in her debt, and I'm so grateful for all of the great work that she did in creating and advancing the organization and that has allowed us to be where we are now. So with that, I will turn to our panelists, and as I said, I'm going to start with Nancy to give us kind of a bit of the overview. We read a lot of stories. There's a lot swirling around, but really, what is this coming out of the sort of the Title IX, Title IX itself, the new policies, and how the universities are administering them? So, can you kind of orient us in this discussion?
Sure, for a short time, because I think this panel belongs to others as well. I come to this topic, and I came to the article that I wrote for the American Prospect from an incredibly schizophrenic background. Schizophrenic from the very beginning of my career. I was, on the one hand, a civil rights lawyer doing sexual harassment cases, representing battered women on the one hand, and on the other hand, I was a criminal defense lawyer. The way in which I reconciled those two hats, as I describe in the article, is that I refused to defend men accused of rape. All the while, I would bring cases on behalf of women who had been sexually assaulted against their psychiatrists or against law schools or colleges that had inadequately provided protection for them. And then I, shortly before I became a judge, wound up, I won't go into details, representing a young man who was accused of rape under circumstances that I never would have believed I would have done. He was a friend of a friend. And the charges against him were unlikely. And I talk in the article about how the experience, he was convicted. I didn't try the case. I passed it on to a partner. I didn't want to break my record of never representing a man accused of rape. I did the appeal. The conviction was reversed. It changed me. I felt very chastened by that experience because, but for, candidly, my intervention, he would have been in jail. The woman made the accusation. It was supposedly his first sexual encounter. The woman made the accusation something like 9 or 10 months later. A month after the accusation, she invited him to her parents' house for the weekend. The witnesses, neighbors on the floor, I mean, there was simply no evidentiary support for her claim, and behavior inconsistent with her claim. I say that I tried the case, I did the appeal, knowing full well that it could well be true that women who are traumatized behave in odd ways, and it could well be true, but the only measure we had of truth in a situation where we were not in the room with them was there any support for her accusation by what anybody else said? How did she behave immediately after, et cetera, et cetera. The long and short of it is, though, it changed me. I become a judge. I barely deal with the issue, except I deal with sexual harassment cases. I deal with domestic violence issues only in connection with offenders who we had sentenced who were on supervised release. For the most part, not being involved in this. Then I go to Harvard. I leave the bench 3 years ago, and I'm at Harvard. And Harvard, in response to OCR, like colleges across the country, changed its sexual assault policy in a way that was extraordinarily troubling to me. Now, I'm going to pause at this point because my response to this came out of a criminal case. That actually, I think, was the beginning of the debate that Alexandra and I have had. I've had with some of my students that the criminal model here and my experiences in a criminal case should not be the model here, but let me back off. There is no question that there's a tremendous problem with respect to sexual assault on campuses. There's no issue there. There's no question that it was right for the women's movement to scream and scream loudly about it. There was no question that it was right for the media to cover it to the extent that it has and will do in the future. As I say in my piece, it was almost as if women had to speak loudly and over again in order to be heard. There was no question that it was right for OCR to suddenly deal with this, the Office of Civil Rights to deal with this seriously. And there was no question that it was right for the universities to finally address it in a way that they had not before. The only question was whether or not what they did, what Harvard did, which I can speak to, went too far. If nothing else had happened, and Harvard had not changed its procedures, except by changing the burden of proof. The burden of proof had been clear and convincing, which is the burden right under beyond a reasonable doubt. So if Harvard had made what OCR, in fact, encouraged universities to do, which is to change the burden to preponderance of evidence. Preponderance is 50.1%, a tiny bit. Clear and convincing is a little bit more. Beyond a reasonable doubt is the highest burden. If it had been changed just to that, these accusations would be tested by that standard. Coupled with the extraordinary attention to this, I have no doubt that women complainants would come into disciplinary proceedings with the presumption that they were right. That's what I had seen, in fact, in the case that I describe many years before. That all of a sudden there was enormous attention to date rape, and under those circumstances, everyone assumed that this young man was probably guilty, no matter what the other evidence showed. So if nothing else had happened but this extraordinary and good attention, plus a fair preponderance standard, women's claims would have largely won across the country. But Harvard and all the universities, many elite universities, went much further, implementing a procedure which was 100% administrative. By that I mean there's a Title IX office, as it should be. Title IX office is charged with implementing Title IX. Title IX quite appropriately deals with discrimination against women. Title IX is perhaps the greatest success story of the women's movement, by the way. Sexual assault interferes with a woman's experience of education, interferes with her ability to be a full and equal participant in her education. Title IX office should be robust, as Harvard provided. But Harvard's procedures were as follows. There was an administrative office. The administrator would appoint an investigator from the office and someone from another school. The investigator from the office and the other person from another school would investigate, ask whatever questions they wanted, talk to whomever they wanted, and issue a report. There would be an appeal from the report. The accused had an opportunity to look at the report and could appeal from it. The only appeal was if there were procedural errors or if there was new evidence. Everything we understood about process, not even criminal process, but fair process, was absent in this. There were no counsel, no lawyers involved. The woman could have an advisor. There were no provision for lawyers. Columbia and other schools had actually had appointed counsel. There was no hearing. We'll have a discussion about what a hearing would look like. Hearing doesn't have to be with the accuser, the accused lambasting the woman. There are various kinds of hearings. There could be a hearing on questions, just asking questions. In fact, that's something Alexandra had proposed, where one side submits questions and then the hearing officer asks the woman questions. But there was no place in the Harvard policy for both sides to tell their story where you could evaluate credibility, etc. There was no right to counsel. The judge of that adjudicative proceeding was the same office that had investigated and the same office that was going to hear the appeal. And as I said, there was no counsel, and the appeal was essentially not worth the paper that it was written on. 28 Harvard professors, of which I was one, argued that you didn't have to go that far to address the clear issues that were involved here. In other words, one didn't have to go from nothing or, essentially a very, very difficult process for the women to slide to a fully administrative process, that there was something in between. And ironically, Harvard Law School actually has implemented the in-between, which in response to the Harvard University's policies are what I described. Harvard Law School now has said that because of our unique pedagogical mission, we care about the fairness of the process. And there is now lawyers, appointed counsel, a hearing along the lines that I've described, not where the accused can confront a victim. The accused can confront the victim in traumatic and difficult circumstances, but where each side offer questions, and then the panel determines which questions are appropriate and proffers the questions to the witnesses. There is a decision that comes out of that panel. The panel is independent of the Title IX office. It's outside experts, and there's an appeal from that. There's an appeal from that to the tenured Harvard Law School faculty. I see that as the in-between. So I don't want to occupy too much of the time. I sense here these are terribly important issues, but as I said in the piece, the women's movement, the concern about sexual assault is not addressed if the process of adjudication doesn't look legitimate. And we see from the press what happens when there is even a hint of illegitimacy in the process. I am older now. I've been around for a while. Attitudes don't change in 3 or 4 years. And the danger here is that if we don't provide a legitimate process, benighted attitudes that I grew up with, the assumption that women typically lie about sexual issues, are lurking beneath the surface. So I saw it as in the women's movement's interest to come up with a more legitimate process. Let me just say just 2 more things about going forward. There are issues about the protection for sexual assault and differences between the way we deal with racial assault, right? Race discrimination. Title IX is only about gender. And we have a process that is now imbalanced about the procedures to deal with racial harassment and the procedures to deal with gender. We've filled the airwaves with discussions that are more about sound bites than our reality. So on the one hand, it is right that we shouldn't be blaming the victim. On the other hand, blaming the victim cannot mean you don't say she's lying. Blaming the victim can't mean that. There are inconsistencies in her account. There are things that she's saying which are not true to other witnesses. That can't be, that's about process. That's not about blaming the victim. We have to deal with alcohol. The Harvard policy treated if the man sex under impairment as rape, not incapacitation, but impairment. If she was drunk and impaired, not unconscious, but impaired, it could be rape, but his impairment didn't count. We have to deal with alcohol and sexual activity on campus. And we have to broadly try to understand the relationship between sexual violence and equality. Alexandra and I were just having a brief conversation before now about how I have always believed that sexual violence was a symptom of inequality. Women who felt powerless in the rest of their lives would then feel powerless to resist in sexual situations. The irony is, of course, that if this is happening on campuses, which are arguably the most equal places. So the issue becomes, we need to look some more at the causes of this, the reasons why this kind of intervention was necessary, the reason why women felt abused, why women are abused in this way. And finally, we have to recognize the continuum of activities here. And people will call me blaming the victim with this. There's a difference between forcible sex with someone who's unconscious, sex, the person who feels remorse after sex, the person who believes that she made a bad decision, the person who wakes up, as in the case that I described, 10 months later and said, boy, that was pretty yucky. That can't be the subject of a disciplinary proceeding, and we have to figure out a fair process that enables us to sort out one and the other. Thank you.
Nancy, that was a wonderful exposition of all of the issues that that are out there and why this subject is both very emotional and quite complicated. One of the things I'd like you to talk about, Alexander, is because your piece was very strong in talking about the distinction between civil and criminal process. And the fact that in the case of the university, they are actually charged with enforcing Title IX and its mandate that there be to avoid, to prohibit sex discrimination on campus and to make sure that the women have the ability to engage in an educational program just as much as the men do. And so there are other sort of analogies for disciplinary proceedings in terms of, somebody who cheats on a test or someone who steals from their roommate's wallet or in some other way does something that might be grounds for expulsion. And yet we seem to talk about these things very differently. And so can you talk a little bit about your approach and that distinction as well as the other disciplinary proceedings and what kind of appropriate analogy we should draw, or should they be totally different, sexual assault versus cheating or stealing?
Sure. I think that's a really important question because it's absolutely true that we have been addressing disciplinary responses to sexual misconduct as like a whole different beast from schools' general disciplinary actions. I think that's really dangerous for a couple of reasons. I think that we often forget that people get suspended and expelled for schools for reasons other than rape. That hasn't really been part of the conversation recently. I think that's important in part just because it's not like schools are new to this game. It's absolutely true that schools are paying increased attention to these particular kinds of harms, but they have disciplinary procedures. And I think that one of the dangers is that when we talk only about sexual misconduct, which unfortunately ends up being a conversation only about rape, which leaves out harassment, intimate partner violence, stalking, other kinds of gender-based discrimination, we end up thinking that we're talking about the criminal law. And I think we see that the criminal law really has a monopoly over our imaginations when it comes to thinking about responses to gender-based violence. We see this in the responses in some state legislatures across the country where their first idea to solve the problem is to say, why don't you just turn everything over to the police? That's a really intuitive idea if you have faith in the criminal justice system. There's both a question of whether, even if all of these cases made it to the police, what good that would do. But also, I co-direct an organization called Know Your Nine, which is a student campaign to end gender-based violence. And we've done some informal surveys and also just spoken with members of our team and survivors who get in touch with us. And what they say is that if my school was required to hand this over to the police, I just wouldn't have told anybody. And what that means is that the police certainly aren't holding anyone accountable. Schools can't hold anyone accountable. And what worries me the most is there's no opportunity for survivors to get the services that they need. We talk about Title IX as purely a law about punishment, but it's also a law about accommodations, about schools stepping up and saying, you've faced this form of discrimination. What can we do to make sure that you can continue to learn? So we have this criminal law monopoly on our thinking, which means that then once we start thinking about when schools need, as part of ensuring students' continued education, to suspend or expel the person who harmed them, we start thinking about mini trials. And I think that this is telling. There was a controversy. I'm a 2L at Yale, and Jed Rubenfeld published a piece last year which used this language, these mini trials for rape. Shouldn't we just get them into real trials in the criminal justice system? And these aren't mini trials, and they shouldn't be mini trials. Courts have largely kept their hands out of school disciplinary issues, I think for some legitimate reasons, for some illegitimate reasons. But one thing that they've been very clear about is you have to have fair procedures, but that's going to look different in a university context, both because of the limitations on resources available to universities, but also because of the unique mission of a university and the unique character of that necessarily exclusive community. So I get excited about the opportunity to talk about campus gender-based violence adjudication in concert with all other forms of disciplinary action, because I think it helps survivors of gender-based violence, and I also think it helps students accused of other forms of harm. So on the one hand, I think we've seen that whenever we talk about rape in a silo, it really ends up hurting victims. Michelle Anderson has a really powerful piece where she talks about how university procedures that are unique to gender-based violence, including Harvard's old policy, have all these additional requirements for victims. Like they had to have corroboration. Often schools had time limits because there's this idea that if you were raped, you would know it immediately, even though survivors' experiences make clear that that's not true, that often people need some time to reflect and feel comfortable speaking out. So I think that so it really helps victims to push this into a conversation generally about what universities should do and how that's going to look different than criminal process. But also, and this is something that gets really passed over, but I think it's safe to say that the Office for Civil Rights guidance on how schools should handle these cases offers some of the strongest procedural protections for accused students that we see in federal law or guidance today. The Supreme Court says basically you need some kind of hearing and some kind of notice, and OCR goes into a lot more details. And importantly, because OCR says that in this spirit of a quality promotion law, again, Title IX is an anti-discrimination law, every protection you give to one side, you have to give to the other side, which means that as OCR gives more protections to alleged victims, they're also giving more protections to students accused of these harms. But there's no real reason that we should narrow these protections only to these kinds of cases. What about students who have suffered or have been accused of discrimination on the basis of race or disability, so under Title VI or Title II? What about students who physically but not sexually assaulted a classmate in a way that they could face suspension or expulsion, but doesn't, in those circumstances, implicate any kind of equality concern? So the conversation I would love to have is, let's take, not only have we not been talking about gender-based violence for too long, but we haven't been talking about student process, period, for a long time. So let's take this as an opportunity to have a public debate about protecting the opportunity to learn for all students. And in the process, we're going to sort of shed a lot of the cultural baggage about rape as a kind of special crime, which, though often expressed in generous terms toward victims, always ends up kind of shooting us in the foot.
Alexandra, that was terrific. And your comments are so thoughtful and raise a lot of questions that I'm sure we'll get shortly from the audience when we get to that point. But I want to turn to Lisa Brown now, who comes with a special vantage point, being the general counsel of Georgetown University, and being in charge of the response to the Office of Civil Rights Policy, as well as the needs of students and other stakeholders in the university. So can you just give us a sense of sort of what has transpired at Georgetown since the new recommendations came out, and how have you responded to them?
So I guess I would start by saying this is not a new issue. This is something that we have dealt with for a very, very long time. And for Georgetown, part of our mission is cura personalis, care for the whole person. So this is something that we have for decades have actually been working on. We are, like every institution, have been doing more and more on it. And I guess let me start by making one point, which is there's a distinction between the support that we give to a survivor and then how we conduct our student conduct process. So there's a lot of support that you want to give to somebody who comes forward and says, this horrible thing happened to me. And there's a lot that we do around that. But when you get into our conduct process, we are all about what is a fair, equitable process for both parties. And it is an educational process. It is in the context of, that is the way that we look at it. And probably what would help is, let me just, given the detail that Nancy did about Harvard's, walk you through what ours is right now. And it answers your question because some of these things are new, or things that we have implemented in response to whether it was OCR or the White House Task Force, the different players that have been weighing in. And so if you are, as a student, and this is not in our, if somebody complains to our Title IX coordinator, the Title IX coordinator will make sure that the student gets if they're a survivor, they get the assistance they need. If they want to file a complaint, it then moves over to the student conduct process. So it's a completely separate process. A student files a complaint. Somebody in the student Office of Student Conduct will sit down individually with the complainant and the respondent, will explain completely what our process is. If you're the respondent, we'll say, here's the complaint, here's what happened, and it's actually, the complaint is written. The respondent has a chance to, in writing, respond. What we have recently instituted is an independent investigator who then, so the complaint and the response are handed to an independent investigator who then interviews the complainant, the respondent, interviews the witness. Each one has a chance to say, I want you to interview this witness or that witness. The investigator will do that before the investigator writes up the results. And all the investigator is doing is actually what are essentially the facts here. What has the respondent said? What's the complainant said? What have the witnesses said? They do not make a determination of violation of any part of our code of conduct. And both students have and what I'm describing now is our undergraduate student-on-student process, which is really how most of these cases arise. The students have a chance to talk to the investigator about how the investigator is going to characterize their interview. And then after the investigator submits their written report, each student also has a chance to file a written response to that report. That whole package is then given to the hearing board that will be reviewing the complaint. And one place that I do think, so this occurs within our general conduct process, but we do have special procedures in place because of the nature of these cases. So what we now do is that it's a panel of three, either faculty or administrator and one student, unless the two students agree they don't want a student on the panel. And this is a specially trained group. So we have a pool of individuals for sexual assault cases. And they have received in-depth special training, both about trauma, but also about the burden of proof, assessing credibility, how do you ask questions in this delicate situation, given the nature of these. And I should say, too, these cases, and I've been doing this for 2 years now, and I should say I think I've spent more time, we as a university don't spend more time on any other issue. I didn't say that very clearly, but we spend more time on this issue than anything else. These cases are excruciating. And they are, the case of the rape in an alley is very unusual. These are people who know each other. These are people who used to be dating, first time for both of them. I mean, these are just really, really difficult cases. And so one thing is you really want your hearing panel to be as educated as they can be about handling these, because they are so difficult, and you want to make sure that they're sensitive to the issues and that they are fair to both sides. I mean, we really are about making sure these are both our students. We're not biased towards one student or the other. We're trying to create a safe campus that's respectful and fair for everybody. So the hearing board will then separately interview, to Nancy's point, each of the students. We have now a closed circuit TV option, so the students, if they want to see each other, they can. If they don't want to see and just hear, they can just hear each other. They have the ability to submit questions to the hearing panel for the panel to make a decision about whether to ask them, because sometimes the questions you actually really don't want the panel asking the questions. And the panel then makes a decision based on the preponderance of the evidence standard. And they take these very seriously. I mean, maybe one way of sort of over essentially the last 2 years, Georgetown had 12 cases. 6 of them resulted in suspension, 4 resulted in a finding of no responsibility, and 2 resulted in expulsion. So they wrestle with this standard, and they think very hard, what does it mean to be more likely than not? And a lot of these cases are credibility determinations. And so so the standard is obviously very important, but for us, it's been, because of that standard, really making sure that the panel understands what it means and that they're being thoughtful about how they evaluate it. If there's a finding of responsibility, there is then a determination of sanction, and if there's a finding of responsibility, the respondent has a chance to appeal. And for us, it's substantial procedural error, new information, or a substantially disproportionate sanction. So that's an additional one. And it is a new, an appeal panel in effect that hears the appeal. So now this is, and I guess let me add in a couple of other things in terms of we now have, which is new, we have a respondent's bill of rights and a complainant's bill of rights, so very clear what the rights are for each party. They get full access to materials. We're not showing some material to one person or anything like that. You have a right to an advisor at every stage of this, but it is the students who speak for themselves. And we now have respondents' process navigators, so somebody to help the respondent explicitly work through this process in addition to who's helping the complainant. So that's, I guess, to start in terms of framing it. That's what we're doing.
Thank you, Lisa. I think we have a lot to talk about. We have danced around a little bit the burden of proof in the standard. So I thought I might ask Nancy and Alexandra to respond a little bit, or Lisa, you alluded to, I wasn't sure if you were saying it was clear and convincing, or if it was just.
It has to be.
Well, ours has to be preponderance.
Everybody.
It's required by.
So preponderance is what's in the requirement by OCR.
Right. OCR only required, to some degree, it's also an interesting story, is that OCR required that the burden changed. Numbers of institutions then went way further than what OCR, sort of looking at the subtext and not just the text, to the kind of procedure that Harvard had, which was totally administrative. And now, and OCR has now approved Harvard Law School's adjusted policy. So it's clear that the minimum that the government was demanding was a fair preponderance and other kinds of protections, but that was not requiring the kind of process that Harvard had implemented.
And I would add too that there's no one right answer here. Different institutions have different cultures, have different, and so I think you have to do what I think you do want to. I think one thing that we all agree on is you need to have a process that's fair to both sides, and I think that's important for both parties to this, and it's important for the institution. But exactly how you get there are places that reasonable people can disagree.
I agree with Judge Gertner that many schools have gone beyond what OCR required, in part just because OCR doesn't say, here's your policy, please implement it now. It did require more than just the preponderance. And some of that comes from the 2011 and 2014 guidance, but some has also come from their resolution agreements with universities. So there was a resolution agreement with Montana, that was actually a joint DOJ and DOE investigation, and that's been called sort of a blueprint for what some university reforms could look like. This is probably an unpopular opinion on all sides, but I think we spend too much time talking about the preponderance of the evidence. I think that there are many more policy changes that are important to survivors. I also worry that it sort of perpetuates this idea that these cases are always he said, she said, and because of that we overlook external evidence, so like roommates who overheard what happened, that kind of thing. With that being said, I do think it's the most equitable standard of evidence. I think it's what we use in anti-discrimination law broadly. We have decades of precedent that this is the right one. Also, before OCR started telling schools to use the preponderance, most schools used the preponderance. Actually, most schools didn't specify any kind of evidentiary standard. Those that did chose the preponderance. And I think it's telling that, sort of going back to this rape exceptionalism, that the thing that got people angry was when we started talking about it in the context of gender-based violence, and suddenly we have this like poor young man with a bright future that we're thinking about in a way that we don't think about that poor young man with a bright future when he like punches his roommate in the face. I think that just to address Judge Gertner's point about adding the media to the preponderance. Look, the media is a really weird thing in its coverage of gender-based violence. I think particularly because we're only sort of now getting out of the point where it's just like sad rape girl story over and over again to talk about, well, what's the impact of this? Like, why do we care about this from sort of an equality promotion perspective? I'm hesitant, though, to say that that is creating a presumption that the alleged victim, who is not always but generally a woman, is right. And so we've got the preponderance standard. You put on one side media attention, that schools get a lot of blowback when a survivor goes public. I think that we, one, have to note that that's really hard to do. Obviously, it's wonderful that there are more students, particularly more women, coming forward to talk about their experiences publicly. It's not super awesome to have your first Google hit be that thing that happened to you freshman year. People get death threats in response to going forward. So I don't think that this is like now, like you file a complaint and then you go call CBS. I also think on the other side of this equation, we have misogyny and centuries of history that tell us that victims lie. We have everything from the Bible to the model penal code telling us that women like get pregnant or you don't call them back and suddenly they're accusing you of rape. So I worry about the influence of these sort of like public media courts, but I don't think it's as clear that that suddenly means that the scales are tipped in the complainant's favor.
The only reason I say that, I actually served on Harvard's ad board. It was where you put, you put ex-federal judges, you put them there to die. I was on, really, then I got off it. Because think of it, when the Harvard policy was completely in the Title IX office, if you found for the man, you were vulnerable in this climate. Think about some of the cases that are the famous cases were adjudicated cases where the woman complainant, for perhaps good and sufficient reasons, came out and said, I don't agree with the adjudication. I don't know, Hobart and William Smith is one that people write about where there was a horrible, vicious, horrible rape, but they could not identify who the perpetrator was. So the university had no one to penalize, had no one to discipline. The Columbia case, the woman walking around with a mattress, was also a case where adjudication. You may not like the adjudicative process, but she didn't, it came out against her. That's different from the cases where people were dissuaded from bringing charges. That's an entirely different issue. But so if you find for the man, you're bound to be criticized. If you find for the woman, you are not in this climate. You're just not likely to.
I would say, though, we navigate this. We are constantly thinking about both because actually in today's climate, we are as likely to be sued by a male student as we are by a female student for a process violation. And so it does then come down to really what the topic of this panel is, which is what is a fair process for both?
Right.
Which we're trying to figure out. And part of what is hard, honestly, as an institution, is the playing field changes with every OCR resolution agreement, so that you implement the Dear Colleague letter, then you have the VAWA reauthorization, then you have OCR's Q&A, and then you have the White House Task Force report, and you have all these resolution agreements. And we are trying so hard to get it right for our students, and you have constantly these things coming in. And I think we all have the same goal here, right? It's to try to get it right and to do your best, and we keep working on that. But it is something that is still, I think, in process.
Mm-hmm. Well, I think Alexandra had wanted to jump in quickly, but then I want to go to questions because we're at the halfway point, and I'm sure there are a lot of questions out there.
Yeah, I was just going to talk about process from suits from accused students, which interestingly, if you actually look at the text, look a lot like suits from complaining students who feel like they didn't get adequate support, didn't know what their rights were, which gives me hope that there's sort of a common solution, that these are not warring interests in some way.
So I'm going to open it up for questions. I'd say if there are members of the media who'd like to start us off, I will recognize you first. If not, I will just go on to broader questions. You young woman here. Because I don't see. Yeah.
Oh, you're gonna hold? All right. So I guess it's to everyone, but I guess specifically Alexandra, about not turning this over to the police when you're getting lawsuits from both men and women, and it's looking like the process is just all over the place for different schools. OCR has been coming out with all these guidelines that have been changing. Schools don't really know what to do, and then they keep changing. That instead of trying to just create this separate judicial system, why not work on trying to fix the actual judicial system to be more supportive of victims so that you don't have to also go through all the other problems that we're facing now? Because they already have that pretty much solved. I mean, that's just, I don't know, it's been bugging me.
I guess I would disagree that they have already solved that one. And I say this both as someone from a public defense background and as a victim advocate, that as much as schools are failing, I think the police are doing a worse job. They are both failing to provide services to victims. And I don't take it as an obvious good to have more convictions, but if that is your rubric for deciding how good of a job the police are doing, something, I think like 1 in 20 reports that actually make their way to the police end up in a conviction. So what I see, and again, if you have more faith in the criminal justice system, you're going to have a different answer. But part of what I see is we have one system that's struggling, and so our solution is to pass it over to another system that's struggling. But I also think it's important to recognize that these procedures are doing different things. The point of school decision making is not to be a sort of local criminal justice equivalent, but to ensure that students can continue to learn despite facing gender-based violence. And because of that, I think that if we were to pass this along to the police, we would lose all of these equality concerns and all of these protections. And I think that, again, we would also just end up with an environment where no one feels like where students feel like they can talk to no one. And I think it's also just important as a last note to remember that we already have multiple systems dealing with these harms. So a survivor off campus can theoretically bring a civil case as well as a criminal case. And what I take as sort of the macro push sort of off campus from what we're learning on campus is that we need more civil options off of campuses, because it's clear that all sorts of survivors are looking for alternatives to the criminal justice system.
I also think there's a definitional problem here. We are talking about a continuum of conduct. And at one end is clearly criminal, predator, violence, no question about it. And as to that, and I agree actually that the criminal justice system is flawed in numbers of ways, not the least of which with race, right? I mean, the story of rape cases in the criminal justice system is not a happy story. Rape cases where the accused is black, it's not a happy story. So and with rape, and I want to say sort of, forcible rape, there's clearly an overlap. The universities are concerned with that, and the criminal justice system is. But also, we're talking about sexual harassment, and we're talking about a continuum from everybody was drunk. There is no way the criminal justice system is going to take that case. And perhaps we shouldn't be either, but that's part of the definition we're dealing with. Everybody was drunk, somebody was more drunk than somebody else. Somebody felt pressured by the environment. A lot of these cases that you're hearing about are sort of remorse cases, where the case that Emily Bazelon wrote about in the New York Times is either a case of forcible rape at the beginning of a relationship, or it's a case in which after the relationship proceeded and feelings waned, she felt remorse about what she had done. That's not a case the criminal justice system is going to take because of the standard. Maybe it's not a case that, it's a case that the universities are going to struggle with, but maybe that's not a case that ought to fit the definition of sexual harassment either. I don't know, but you're talking about different, much more ambiguous and much more equivocal conduct that is within the university's purview that is not at all in the criminal law domain.
I would just add to what Nancy said that these two serve very different purposes, right? One is is an educational process for violation of community standards, and the other is to deter crimes. And as to Nancy's point about the continuum of behavior, some of it that is right, we as a university, we really do have to think about how we're going to handle is something that the criminal justice, it doesn't get to that standard, and which is part of what, you do have the different burden of proof, with the clear and convincing evidence. There's a reason that women have been reticent to go into the criminal system.
But there's a real question of what the norms of behavior are. I mean, about the norms of behavior are now. There's a real question about whether we how much we should be focusing on. This is to Alexandra's point, the adjudication. There's a cause problem here. There's a what about drinking and what about sexual mores have led to these. Not the predator situation. That's clear. That didn't require any change. But what about the environment has led to these kinds of claims of women feeling that compelled to have sex under circumstances where afterwards they felt pressured. That's a women's equality issue, and I actually would love to see a larger discussion of how it is we're there and we continue to be there. In other words, a lot of the claims that we heard were claims of women feeling pressured under circumstances that the criminal justice system would never recognize, no force, et cetera, and you're talking about social environment pressure. I don't know what process can easily deal with those kinds of cases. We have to talk about how that happened.
Well, and we haven't been talking about prevention. We're talking about the response. And I think a big part of this is what are you doing, particularly with your freshmen? We now have Think About It, an online program that every freshman completes that is about responsible alcohol, healthy relationships. It is to get students thinking about this, and part of our freshman week is a play as part of orientation with breakouts afterwards to talk about these issues. And we have to come at it on that and working with students. I mean, this is not, I can't, lecture to students, they're not going to listen to me. We really do have to, but you have to engage the students in this. And what is an effective way of encouraging responsible behavior?
I wonder if part of this too, and I am, sorry, I'll really quickly. I think I disagree with Judge Gertner's sense of what kind of harms that we're seeing. I think that actually a lot of them do meet criminal standards, but for legitimate reasons, people don't want to go forward to that system. But I also think it's important that we are able to acknowledge harms that we don't know how to punish, because I think that is one of the few ways that we're going to be able to have these kind of community conversations. And as a background, and that's also, I think, a little dangerous for a university, because some of that's going to mean, why is only a quarter of your faculty women? Why, what are the obstacles to women feeling part of the university community in a really robust way beyond whether they're being assaulted?
That's a great point. How about the gentleman in the back standing up? You got a microphone over there? Then the rest of you, can you hold up your hands again so I can start figuring us out? Then we can get as many questions asked.
It seems difficult to talk about whether the process is fair or not, and I should talk about what the results are. In other words, the criminal justice system has evidentiary standards and a burden of proof and all of that because the results of a felony conviction are so lasting. Can you talk a little bit about what you're seeing about the results for men that are being kicked out of colleges, whether they can go on with their lives, et cetera?
The Huffington Post did a study on this and looking through some university materials and found that most students who are expelled, which first of all is a very small proportion not only of students who face these charges but who are found responsible for these charges, even of that small population, very few of those are facing obstacles to re-enrolling in or transferring to other universities, which brings up like a whole other host of questions about basically moving a dangerous person from one campus to another. With that being said, if it is seriously affecting some people, that's something that I think we should care about, sort of not just the harm of the lost semester, but the stigmatic harm of having been expelled for this kind of thing. I just think what you hear from some of the men's rights activist groups is that there is nothing, as they tell me on Twitter, there is no harm like being expelled for rape. And I guess my question would be, when I was a freshman, there was someone who painted in red paint that looked like blood all over his roommate's dorm, like, I'm going to kill you. And I think that probably doesn't look so hot on a job resume either. So I just think that this is a problem. It is not a unique problem.
Bob, yes, bring the microphone up.
Thanks. Hi, Bob Kuttner. There's an old quote from Nelson Aldrin that says, never spent the night with a woman whose troubles are greater than your own. And I'm recalling back in the day that if you were a gentleman, you didn't manipulate or coerce a woman into having sex, even though that was endemic. Not exactly. This is not a new problem. Men have been manipulating women into having sex since Adam and Eve. It seems to me that one benefit to all of this stuff is that maybe a lot of young men are going to think twice before they manipulate a woman into having sex, whether she's drunk, whether she's sober, whether they've raised unrealistic expectations about what the relationship is going to be, all of it. So even though we're struggling to figure out exactly what the criteria are, exactly what's criminal, exactly what's civil, if this results in young men being more civil, in a different sense of the word, that's progress.
Yeah, I completely agree with you. I mean, after the article, I got called by various people who are probably on your Twitter feed who are, who said, "Oh, you're now going to be for men's rights," and I said, actually, I am not. I'm really not. I was incredibly judicial in this piece. If this discussion, if the risks make a man say, pause before doing what you're describing, that is not a bad thing. And if this whole thing means that young men and women are talking about what the rules are, frankly, it's interesting, the discussion about affirmative consent, right, which has the notion that a man has to get a yes and not a maybe and not silence. There are some problems with that, but at the very least, it's a very interesting proposal because it suggests that women have to own what they're doing. Women have to be clear about what they're doing. And so to some degree, some of the problems here come from very old-fashioned women's attitudes about sex. You don't really want to say that you want it, and so you just do a little dance. And if he misunderstands the dance, well, that's too bad. So if it's clarifying some of these rules, it is not a bad thing at all. My concern was, even if the person's not going to jail for being kicked out of school, in this competitive economic environment, stigma matters. It doesn't matter intergalactically like jail, but it surely matters, and we should be concerned about it.
I'm just reminded of, I think, the incident at Yale of a group of frat boys marching around old campus or something and saying, no means yes, no means yes. There's this issue of consent and what consent actually means. In that case, even saying no wouldn't really be effective, and I think it harkens back to something Alexandra and you, Nancy, both talked about in terms of the sort of the endemic gender bias in this whole conversation, and that no matter what the women say, no, maybe, or yes, it's might in many circumstances be interpreted as yes. And so I think that just leads into the complexity of this, is that as women get more empowered to say no, that then no really is interpreted as no.
Right.
That's the I think to Bob's point, that the conversation now is what the frame of the proceeding was the sex unwanted. So it is all about the consent, and so that this is about students understand. You need to know it. You want consent here, right? That's the healthy relationship, and so having the dialogue around having that from both whether it's male female, male male, female female, whatever, that's part of the conversation is a healthy thing.
Well, I think you wanted to.
In the old days, a guy was taking the risk of getting a bad reputation or maybe feeling guilty. Now he's taking the risk of getting busted. That's progress.
We had a question over here.
My name is Roberta Stanley, and I'm a K-12 public education advocate and a former state Title IX coordinator. Somebody alluded to the resources that higher education has and K-12. Frankly, these days, neither of them have resources to develop the system that's probably called for here. But Lisa, I wanted you to outline more thoroughly the makeup of these hearing boards you have. Are they all lawyers? Are they school psychologists? Are they social workers? Who serves on these hearing panels?
So it's not restricted. It's not. It's faculty, administrators, and students.
So it's a combination thereof.
It's a combination, and unless if the students involved don't want a student on the panel.
Yeah. Well, who vets them?
I'm gonna ask Josh Dermott, who's on my team, is here because I actually don't know the answer to this question.
Yeah, sure.
Pass this.
Please pass the mic.
As Lisa said, the process would be open to anybody that falls into one of those categories. It's open to all students, all faculty, all administrators. We have a group of people within, within Student Affairs who accepts those applications and reviews them. There's interview processes, so it's kind of a standard.
Is it voluntary then?
It is. Yep.
Yes.
Yes, yeah. We, especially for these cases, I think we only want people who are genuinely interested in this and willing to put in, as Lisa said, the extensive training that we give them as well.
And then who just determines who they are? Like, who are they applying to?
It would be our Office of Student Affairs, yeah.
We have a question from Ross Eisenbray in the back from Economic Policy Institute.
Hi. So my question, I think the Alexandra's take on this, that we should look at this as part of, you know, how we want students to behave on campus, and these procedures are not criminal in the first place. They're about what kind of a community we want to have. So Georgetown has a policy, and you outlined different results, and I wonder how those different results, if you could sort of characterize the expulsion versus the suspension, and what non-sexual activity is parallel to that, would have led to those same kinds of results.
So those numbers that I cited were just our sexual misconduct numbers, and the results turn there. You can't say if A plus B equals C. It just doesn't. They don't come that way. They come in every possible type of behavior, every possible set of relationships between the two people. Memories are different. There's a witness or there isn't a witness, or you can't see. You can't. It's not like a math problem where you can just say, okay, plug this in and this in, and then that's the result. So it really is, and the hearing boards evaluate the case before them, and make a determination about responsibility and then about sanction, depending upon what the conduct was and what the situation was. So the severity of the sanction will, the severity of the conduct obviously impacts the severity of the sanction.
But what, just for example, what is the sanction, what was the determined action of the person who was suspended in the sexual case that led to suspension, and what would be the equivalent, or what's an example of something that was non-sexual that would cause suspension?
So I can't get into the facts of any of these cases. But you can get kicked out for cheating, right? You can get it's not only these cases where there's a severe discipline. There's a lot of it could be a severe assault. It could be right there. There's no any of these violations of our code of conduct have the range of sanctions available for them.
Can I just ask a follow-up on that? Do you have the same process?
So it's within our conduct process. There are clearly specific things that we do because of the sensitive nature of these cases. So the particular training that we give our hearing board, the not questioning each other, being out the video, there is, because of the nature of these cases, we do need to treat them differently, but they do occur within the construct of our overall conduct process.
The question up here.
Students.
Yes, please.
He's in charge of the microphone.
Hi, I have two questions. One is if you could comment on the interplay between the criminal system and the university disciplinary system, if both tracks are proceeding simultaneously. And then I had a second question kind of arising from the hypothetical of a male student who perpetrates a sexual assault against a non-student off campus, because in that situation you don't necessarily have a Title IX situation. You don't have an aggrieved beneficiary who's being denied services by the university, but you still may have a perpetrator who's violated the campus code of conduct or is otherwise someone that the university might have an interest in policing, whether or not he's involved in a member of the campus community, and whether or not the university, I guess I'm kind of looking at you for the last one, but whether or not the university would step in or have an interest or allow a citizen non-student to make a complaint against a student.
They do. We do. A non-student can come to us and say, there was this student did X, and we would address it through our process.
Sure. The overlap between the criminal, so we're now talking about what is clearly defined as rape under the criminal law definition and under a disciplinary code. That is difficult, and that is difficult for this reason, which is any lawyer worth his or her salt would tell the man in the disciplinary proceeding that he should not speak, that he should not speak, because if he were to speak, then his words would be used in the criminal proceeding with the consequences much more substantial. So to the extent that these proceedings, on the one hand, the women complainant want them to go on at the same time because she wants not to have him on campus, not to be in the same dormitory. That's very difficult. It seems to me if there's a criminal proceeding pending, the system has to figure out a way to enable typically the man's rights to be respected and have the process go on in some way, but perhaps not have a final resolution until the criminal resolution. I'm not sure. But that raises very difficult problems. I mean, one other possibility, one resolution I've heard of is that they both go on at the same time, but the man doesn't participate in the disciplinary proceeding, but whatever outcome there is subject to review if he's exonerated in the criminal proceeding. So while you go ahead and have some resolution on the disciplinary side, it's not a final, it can be revisited if he winds up being exonerated. It doesn't necessarily have to be, but that is a serious problem, but to some degree it's a problem that the legal system has dealt with in other ways. It's not unusual to have a civil complaint against a potential assailant and a criminal complaint, and he can't defend in the civil case. He takes the fifth in the civil case typically, and that proceeds in some fashion. So it is difficult. What I've seen happen, though, for the most part, is that if there's a criminal proceeding, if a woman decides she wants to go that far, that's usually the process and not the disciplinary proceeding. But the overlap is problematic. It's very difficult.
I'll just say I know that a policy that Yale has put into place is to allow students to withdraw, but there is a note when they're facing a disciplinary hearing, the disciplinary hearing is suspended while they are away from campus, but a note goes on their transcript so that if they try to, it's not a permanent note, but if they were to try to transfer while this hearing was pending, the other school would have noticed that maybe something fishy was going on.
Interesting. So there were some more questions in the back, I think. Here? 2 questions I see. So then whoever you get to first, and then I'll take the next one afterwards.
Thank you. So both of these will be a bit broader. The first one probably to Alexandra, which is from speaking to people who work in college sexual assault, OBGYNs, et cetera, it sounds, and reading what's published in the media, it sounds like the nature of rape cases is changing, and there's more gang rape, there's obviously more photography of it, but almost like choreography of it. There's more anal rape. It just generally sounds like there's more brutality. And it sounds like porn or something else is maybe changing the nature of what's going on. Even if we look at girls who are having casual sex, a lot of girls aren't having an orgasm. Sorry to be super, but it's almost like there's a lot of intimacy lost, which I think perhaps leads to discomfort later, or it's part of what I think is part of a good sexual experience. But then the second question would be maybe to Lisa, and it's a little bit outside the bounds of the legal system, but given that there's a lot of societal violence, there's video games, there's porn where kids might come with 20,000 brutal images, having seen many brutal images, what should we be doing at the university level in terms of researching these linkages and then sort of speaking about rape culture and societal factors?
Sure. I apologize if this is sort of not responsive to your question, but I am not sure that sexual violence is getting more brutal. It might be, and I don't have any evidence that it isn't. But I know that the stories that the media is taking are the really graphic, really brutal ones. So 2 anecdotes. One is that the woman who wrote the story for Rolling Stone that ended up being discredited
University of Virginia?
At the University of Virginia, she called me a couple months before and asked if I knew anyone at Yale. She really wanted to set it at Yale because the first big Title IX case, Alexander against Yale, happened there. That we were part of the complaint in 2011, and I put her in touch with a couple of students who had what I'd call like normal rape stories, and none of them were good enough for her. And it seems unsurprising to me that the story that she eventually decided to publish was one that was like literally sensationalized. Secondly, a close friend of mine was once talking to a reporter about violence within an intimate relationship. The woman said that that sounded like alternative rape, not the kind of rape that she was looking for. And we joked this was like hipster rape, anything outside of this like brutal football player gang rape. And so it's possible that it's happening, and I know that there's been discussion in feminist communities about sort of the prevalence of kind of like casual BDSM that isn't entered into consensually, but becomes sort of just like the fabric of heterosexual sex, and how to sort of proceed through that conversation in a sex-positive way that doesn't shame people who do prefer those practices. But I do wonder if part of what we're coming to understand as rape is really just what, like, the Huffington Post thinks is a clickbaity rape story.
Yeah, I just add to that our cases aren't gang rapes and drunken fraternities, and there are two individuals that were in her dorm room and something went wrong, or they have different perceptions of what happened. So I would agree that I'm not seeing increasing violence, and haven't gotten a sense of that.
There was a gentleman here. Ben will bring you the microphone.
Yeah, I just had a question. It seems that the procedures are not just aimed at rape, that they're aimed at things other than rape and misconduct other than rape. And sometimes by focusing only on rape, we put it in the bucket that leads to analogizing the criminal procedures. And we don't focus on those lesser incidents that are not criminal and may not even be violence, but that we really should push to stop and to discipline and to change the culture. I think if we get too stuck up on the conversation of rape, we lose sight of those lesser conduct, and I don't know how to approach it or what the panel thinks.
But the interesting question is how to define that lesser conduct. So implicit in all of this is a discussion that the women's movement has to have with each other and others, which is, so a woman who willingly gets drunk and, doesn't know exactly where it's going to go, do you have a policy then, like the Harvard policy, that says not if she's incapacitated, but if she is impaired, we say she's then not responsible for what happens? In other words, so there's a split in the women's movement between those who believe that protective policies here, not rape, kind of violent rape we're talking about, take away a woman's agency and responsibility. Let me tell you, this is in my piece. So Brandeis had a case of a homosexual couple that had an intimate relationship for 8 or 9 months, and at the end of that, one of them accused the other of sexual assault at the beginning of the relationship. Brandeis went ahead and investigated and found for the accuser against the accused. OCR came in on the side, is investigating whether to come in on the side of the person accused on the grounds that the procedures were inadequate. It was very interesting. We haven't seen them come in on the side, at least I hadn't, on the side of the accused before. And I speculated that part of the reason is that in a homosexual accusation, there was no presumption of who was powerful and who was powerless. So that they just couldn't presume one or the other, whereas in many of these cases, the assumption is that the woman was powerless, and that's why the line with respect to what comprises sexual misconduct is different. Well, maybe it is different, maybe it should be, but it's a conversation we need to have, and we need to have with young women as well.
OCR has done that once, for whatever it's worth. Once before.
There you go.
So we do have time for just a couple more questions. I see a hand back here and a hand here, so we'll take you two, and then we'll draw to a close.
I think this work is really important, and I am so grateful that the conversation is happening. The next place that these students will hopefully end up is in the workplace. And I'm hopeful that the sensitivity they're developing here, that there are lines and you can't cross them or shouldn't cross them, they will carry with them to the workplace. I'm wondering if any of these procedures are things that any of you have thought these are procedures that employers could adopt, because some of the same issues, the he said, and employers saying, well, I'm not going to take any action because I can't definitively, beyond reasonable doubt, decide who's right, so therefore I'll do nothing. I'll just put a warning, you know, if you did anything, don't do it again. And
That's
move
the
on.
next American Prospect article. The courts, how shall I put this, suck on civil rights cases. I have to put it that way. As I said, my chances for the Supreme Court are long ago shot. But the sexual harassment law, racial harassment law, sex discrimination cases lose in federal court to a degree that is a scandal. In one court in Atlanta, for example, 100% of racial harassment cases were dismissed before trial. So if there isn't that kind of pressure on the civil enforcement side, where will the pressure come for employers to implement these kind of proceedings? The reason why the campus situation is different is because of OCR. And there's not an equivalent to OCR in private employment. So that's another, Bob, it's another article and another panel. No, it's about the court's record. When I was a baby judge, that's what they call you when you start, when they taught us civil rights law, just Title VII law, the trainer, who to be sure had been a trainer from the Bush administration, but the trainer began by saying, here's how you get rid of these cases.
Really?
And that atmosphere continued over the 17 years that I was a judge. So no, unless you have that pressure, that nothing's going to change.
From the perspective of an employer as well as a university.
Well, so some of these, if there's a complaint against a faculty member or an administrator, we have a process for that. So it's a different process than the one I outlined, that's the student on student, but we have absolutely, you go to our institutional diversity, equity, and affirmative action, and you say this is what happened, and there's an investigation that's conducted, and so there absolutely is a process within our community.
So there was one more question over here. Ben, there's the right in up here. A hand. Can you raise your hand up again a little higher? Oh, it's you again. Okay.
You can.
I guess Alexandra brought up something interesting about students who either withdraw or are expelled and then go to another school, and I mean I guess that kind of brings back up that criminal area where maybe you get him off your campus, but if he's such a danger, now he just goes and preys on other people. I mean, how does that get worked out?
The proposal that I keep hearing, which Know Your Nine is internal conversations about, which at this point I personally don't support, is to have permanent marks on transcripts that say you were expelled for a sexual misconduct offense. I worry about that because it treats sexual misconduct differently. I also worry about that because I think that people can change. And like my public defender hat says, we have to give people the opportunity to learn from this experience. With that being said, I think that there are really disturbing class implications of what we're seeing is students transferring from private universities or getting kicked out of private universities, transferring to the local state school, and then assaulting students who don't have the resources available at a private institution to protect them. My cop-out answer is that one law isn't going to do everything, that this is why we have multiple systems, but if anyone has a better idea, I would really love to hear it.
So for us, you can't, if somebody brings a complaint against you, you can't withdraw to get out of it. You can't go to another school and not have the process continue. So there isn't the risk of somebody just going to another campus. And it does and it's not just sexual misconduct. If you cheat and you get suspended or kicked out, that's on your transcript as well. We don't treat it any differently, but it is on your transcript so that any other school that you'd be transferring to would see it.
But Alexander raised something which we can't get into right now because at the very end, but there's a resource question here with respect to the students accused as well. If the university does not provide counsel, even if the counsel can't participate in a hearing, it dramatically affects the outcome. And what happens here is that poor students wind up being disadvantaged in the proceeding, whereas the woman accuser typically has the resources of the Title IX office behind her. The man who's accused, unless the university provides for counsel, doesn't have very much at all.
So that's exactly why we now have an independent investigator to help level the playing field, and why we now have this the individual to help the respondents navigate the process. So we were trying to keep it parallel in terms of the resources for both of them.
Also, I know we have a lot of lawyers in the room, and I think that a really excellent use of pro bono hours would be to represent both sides, or even to come in for 5 hours. This is what Columbia is doing now, 5 hours of free legal consultation to say, here's your shot, this is what we think that you should do.
That's a great idea.
So I'm going to ask the panelists to make any further remarks they'd like before we close, unless somebody has a really burning question that must be gotten out before the end of this. You seem okay. It's been a great conversation. So I just want to ask Alexandra, Nancy, Lisa, you've put some really, really very significant ideas, provocative questions on the table. We've had a really good conversation. I think that certainly for me, I find much more understand kind of what's going on, as well as what the really relevant questions are and where some of the difficulties are. Do any of you have anything you want to say before we end today about, say, what's the next step? What are the things we need to keep in mind? Where do we go from here? How do we make this process hopefully become much more obsolete?
Well, I just want to say, since I wrote my article, as I said, Harvard Law School has a new policy, which looks like OCR is accepting, which is this more middle range kind of policy. That policy matches much more what Alexandra criticized me for not proposing. I proposed it. So we're getting together here. I just want to let you know.
Yeah, I mean, first of all, I'll just say, like, I'm a 2L. I'm kind of a Nancy Gertner fangirl, so this is really exciting to be here.
And we all are.
But, you know, it's really exciting to have this conversation as allies, and I hope that we continue to do that, because I think what we see playing out in the media is it's like the nutty feminists who want all men expelled from campus immediately, and then the only voices that we hear on the other side are these men's rights activists harassing victims on Twitter, and it's nice to see people coming together around shared values about the importance of education. And I guess
very judicial of you.
It's not a traditional characteristic of mine. And I guess I guess just as a closing note, because there are a lot of people in this room who have the ability, who have diverse skills and the ability to really help out here. And I guess my ask of you is that, you know, we only have so much more time that the media is going to care about this. We only have so much more time that this is going to be sexy, and we're going to need your help after that point. There are still going to be students facing lost opportunities to learn after that point, and I hope that you'll stay with us.
That's a great point.
Yeah, I would add one thing on the media point, which is as you read these stories, recognize that universities actually are very constrained in what they can say. So we have a critical eye, because we can't say anything. And so many times you're hearing one side of a story. And then I guess the other thing I would say is I think our goal is the same here. And the question is, how do we do this? And how do we try to get this right for everybody who's involved? And it's going to take all of us to do that. And I think, having thoughtful conversations about it that aren't grounded in the more extreme story someplace is what's really important.
Well, let's give this wonderful panel a round of applause.
April.